Dear students and viewers, welcome to my channel Basics of Political Science. Today we are going to discuss what is the relation between union and the state governments in India, which is a part of the larger discussion of the federal system in India. If you do like the video, please subscribe and press the bell icon for further notification. In India, before the formation of the federation, the states were not sovereign entities. As such, there was no need to protect states. On account of the exigencies of the situation, the Indian Federation has acquired characteristics which are quite different from the American model. The Constitution of India provides a dual polity with a clear division of powers between the Indian and states. It is because that the each being supreme within the sphere allotted to it. Thus, the Indian Federation is not the result of an agreement between independent states, and the units of federation cannot leave the federation. Thus, the constitution contains elaborate provisions to regulate the various dimensions of the relations between the states. Hence, the union is indestructible, but states are destructible. So, what can we say about the character of the Indian federal polity in relation to uh, the union government and the state government relationship? We can say that it is a quasi-federal state where most of the features which are present as an ideal form of federal features are present, but their actual notionalization, that means their actual work in progress or in practice, uh, is cannot be seen, and the tendency is more onto the central government rather than that of the state government. This is why various scholars like Alfred Stephen, Yogendra Yadav, Ashutosh Varshnai has described that it is the state of nations rather than that of the nation states, which was earlier used to describe uh, multinational states like India. That is why there are a conglomeration of various nationalities within the geographical boundaries of India. For example, the caste, the religion, the tribes, these are the various units which are there within the domain of the Indian polity. That is why the peculiarity of the Indian federal character can be discussed as amalgamation of the unitary features and the federal features in one place. The relations between the union and state government can be described into the following manners. Number one is the legislative relations. Article 245 to 255 in Part 11 of the Constitution deal with the legislative relations between the union government and the state government. Extent of laws made by Parliament and by the legislatures of the state, wherein the Parliament can make laws for the whole or any part of the territory of India. Territory of India includes the states, union territories, and any other area for the time being included in the territory of India. Whereas the state legislature can make laws for whole or any part of the state. The Parliament can alone make extraterritorial legislation. Thus, the laws of Parliament are applicable to the Indian citizens and their property in any part of the world. Thus, the subject matter of laws made by Parliament and by the legislation of the states. The Constitution divides the legislative authority between the Union and states in three lists, which are included in the seventh schedule. The lists are the list 1, the union list, list 2, the state list, and the list 3 is the concurrent list. The union list consists of 100 items. The union parliament has exclusive authority to frame laws on subjects enumerated in this list. These include foreign affairs, defense, armed forces, communications, posts, and telegraph. The state list, that is list 2, consists of 61 subjects on which ordinarily the states alone can make laws. These include public order, police, administration of justice, prison, local governments, agriculture, etc. The concurrent list comprises of 52 items, including criminal and civil procedure, marriage and divorce, economic and special planning trade unions, electricity, newspapers, books, education, etc. Both the parliament and the state legislatures can make laws on subjects given in the concurrent list, but the centre has a prior and supreme claim to legislate on current subjects. In case of conflict between the law of the state and union law on a subject in the concurrent list, the law of the parliament prevails. Apart from that, there is a residuary powers of legislation. The constitution also vests the residuary powers, that is, those subjects that are not enumerated in any of the three lists with the union parliament. The residuary powers have been granted to the union government contrary to the convention in other federations of the world where the residuary powers are given to the states. However, in any case of conflict, whether a particular matter falls under the residuary powers or not, it is to be decided by the court. Thus, Parliament's power to legislate on state list is vast and enormous according to the 7th schedule. Another relationship that exists is the administrative relations. It is included within Article 256 to 263, but there are also various shades into this relation. For instance, there are shades of relationship between the central government or the union government and the state government during the normal times and during emergency. And there is also a interstate council which also establishes a basic pattern of relationship between the state government and the union government. There is a financial relation which is established within Article 268 to 293, which is included within Part 12 of the Constitution. Let us see the legislative relations that exist between the union government and the state governments. Thus, the parliament's power to legislate on state list. Though under ordinary circumstances, the union government does not possess power to legislate on subjects enumerated in the state list, but under certain special conditions, the union parliament can make laws on these subjects. For example, in the national interest, Article 249, if the Rajya Sabha declares by a resolution supported not less than two-thirds of its members present and voting that it is necessary or expedient in the national interest that the parliament should make laws with respect to any matter enumerated in the state list. After such a resolution is passed, Parliament can make laws for the whole or any part of the territory of India. Such a resolution remains in force for a period of 1 year and can be further extended by 1 year by means of subsequent resolution. Under proclamation of national emergency, that is Article 250, Parliament can legislate on the subjects mentioned in the state list when the proclamation of national emergency is in operation. However, the laws made by the Parliament under these provisions shall cease to have effect on the expiration of a period of 6 months after the proclamation has ceased to operate, except as respects things done or omitted to be done before the expiry of the said period. By agreement between states, Article 252, the Parliament can also legislate on a state subject if the legislature of two or more states resolve that it is lawful of Parliament to make laws with respect to any matter enumerated in the state list relating to those states. Thereafter, any act passed by the Parliament shall apply to such states and to any other state which passes such a resolution. The Parliament also reserves the right to amend or repeal any such act. For instance, if two or more states, for example, West Bengal, Orissa, Bihar, they want the Parliament to make laws on any provision, they can appeal to the Parliament to make to law on a certain subject. If the Parliament wishes or chooses to do so, they can legislate a law. So, in such a way, that is between the agreement between the states of West Bengal, Orissa and Bihar, a common law can be framed by the Parliament, which is applicable on all those three states after the legislation has been made by the Parliament to implement treaties. According to Article 253, the Parliament can make law for the whole or any part of the territory of India for implementing any treaty, international agreement or convention with any other country or countries, or any decision made at any international conference, association or other body. Any law passed by the Parliament for these purpose cannot be invalidated on the ground that it relates to the subject mentioned in the state list. Under proclamation of President's rule, the President can also authorize, according to Article 356, the Parliament to exercise the powers of the state legislature during the proclamation of President's rule due to breakdown of constitutional machinery in a state. But all such laws passed by the Parliament cease to operate 6 months after the proclamation of President rule comes to an end. In another way, the legislative relations between the central government and the state government, we can see how the center's control over the state legislation dominates in few other areas. The constitution empowers the center to exercise control over the state legislatures in the following ways. Number one, the governor can reserve certain types of bills passed by the legislature for the consideration of the president. The president enjoys absolute veto over them. That is, if a governor thinks that a certain law passed by the state legislature needed to be assented or qualified by the president, he can send the bill to the president for presidential veto, and in that case president enjoys the full veto over the bill that is being passed by the state legislature. Number 2, bills on certain matters enumerated in the state list can be introduced in the state legislature only with the previous sanctions of the president, as imposing restrictions on freedom of trade and commerce. Number 3, the president can direct the states to reserve money bills and other financial bills passed by the state legislature for his consideration during the financial emergency. Center state, that is union government and the state government's relationship on the basis of the administration, that is the center state administrative relations. The administrative jurisdiction of the union and the state governments extends to the subjects in the union list and state list respectively. The constitution thus defines the clauses that deal with the administrative relations between center and state. So, in the first scenario, we will see what is the relation between the union and the state during normal ties. Article 256 stipulates the executive powers of states to be exercised in compliance with union laws. That is, Article 256 lays down that the executive power of every state shall be so exercised as to ensure compliance with the laws made by the Parliament and any existing laws which apply in the state. And the executive power of the union shall extend to the giving of such directions to a state as may appear to the government of India to be necessary for that purpose. Article 257 clearly states the executive powers of state not to interfere with the executive power of union, and it provides that the executive power of every state shall be so exercised as not to impede or prejudice the exercise of the executive power of the Union, and the executive power of the Union shall extend to giving of such directions to a state as may appear to the Government of India to be necessary for that purpose. In short, the Union government can issue directions to the state government even with regard to the subjects enumerated in the state list. Maintenance of means of communication, that is the railway, waterway and communication which are of national or military importance. The Union government can give directions to the state with regard to construction and maintenance of the means of communications declared to be of national or military importance. Similarly, it can give protection to the railways and issue state governments necessary directions regarding the measures to be taken for the protection of the railways within the jurisdiction of the state. It may be noted that the expenses incurred by the state governments for the discharge of these functions have to be reimbursed by the Union government. To ensure welfare of scheduled tribes in the states, the Union can direct the state governments to ensure execution of schemes essential for the welfare of the scheduled tribes in the states. All India services. The presence of the All India services, the Indian administrative services, Indian police services, etc., further accords a predominant position to the Union government. The members of these services are recruited and appointed by the Union Public Service Commission. The members of these services are posted on key posts in the states but remain loyal to the Union government. Delegation of Union's function to the state. The President of India can entrust to the officers of the state certain functions of the Union government. However, before doing so, the President has to take the consent of the state government. But the Parliament can enact law authorizing the central government to delegate its function to the state governments or its officers, irrespective of the consent of such state government. On the other hand, a state may confer administrative functions upon the union with the consent of the union only. Appointment of high dignitaries. Union has major say in appointment and removal of governor and appointment of judges of high court and members of state public service commission. To secure instruction in the mother tongue at the primary stage of education. The union government can direct the state governments to secure the provision of adequate facilities for instruction in the mother tongue at the primary stage to children belonging to any particular linguistic minority groups. Delegation of unions functions to the state. There are various functions of the union government that is being delegated to the state, each and according to the provisions of the constitution. Union to adjudicate interstate river water dispute. According to Article 262, the Parliament has been vested with power to adjudicate any dispute or complaint with respect to the use, distribution or control of the waters of or in any interstate river or river valley. In this regard, the Parliament also reserves the right to exclude such disputes from the jurisdiction of the Supreme Court or other courts. The recent jurisdiction of the Supreme Court regarding the dispute of the water sharing between Tamil Nadu and Karnataka is a prime example. To ensure government of a state is carried on in accordance with the provisions of the Constitution. The union can direct the state governments to ensure that the government of a state is carried on in accordance with the provisions of the Constitution. If any state fail to comply with any directions by the union in exercise of its executive power, the president may hold that a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of the Constitution. Thus, he may proclaim president's rule in that state. Union-state relations during emergency. Under President rules, according to Article 352, the state governments cannot ignore the directions of the Union government. Otherwise, the President can take the action against the government of the state stating that the administration cannot be carried on the accordance with the provisions of the Constitution and thus can impose President's rule on the state. In such an eventuality, the President shall assume to himself all or any of the functions of the state government. Under proclamation of national emergency, Article 356. During a proclamation of national emergency, the power of the Union to give directions extends to the giving of directions as to the manner in which the executive power of the state is to be exercised relating to any matter. Under proclamation of financial emergency. During a proclamation of financial emergency, the union government can direct the state governments to observe certain canons of financial propriety and to reduce the salaries and allowances of all or any class of person serving in connection with the affairs of the union, including the judges of the Supreme Court and High Courts. The Union also requires all money bills or financial bills to be reserved for the consideration of the President after they are passed by the legislature of the state. It is thus evident that in the administrative sphere, the states cannot act in complete isolation and have to work in under the directions and in cooperation with the center. The financial relation between the union government and the state government can be seen in the Indian Constitution, which has made elaborate provisions relating to the distribution of the taxes as well as non-tax revenues and the power of borrowing, supplemented by provisions for grants in aid by the union to the states. Article 268 to 293 deals with the provisions of financial relations between center and the states. The Constitution divides the taxing powers between the center and the states. The Parliament has exclusive power to levy taxes on subjects enumerated in the Union list. The state legislature has exclusive power to levy taxes on subjects enumerated in the state list. Both can levy taxes on the subjects enumerated in the concurrent list, whereas residuary power of taxation lies with Parliament only. Now, the distribution of the tax revenue. Duties levied by the Union but collected and appropriated by the states. Stamp duties on bills of exchange, excise duties on medical and toilet preparations containing alcohol. These taxes don't form the part of the consolidated fund of India but are assigned to the state only. Then the service tax, which are levied by the center but collected and appropriated by the center and the states both. There are taxes which are levied as well as collected by the union but assigned to the states. These include taxes on the sale and purchase of goods in the course of interstate trade and commerce, or the taxes on the consignment of goods in the course of interstate trade or commerce, which is popularly nowadays known as GST. Taxes levied and collected by the union and distributed between the union and states. Certain taxes are be levied as well as collected by the union, but their proceeds shall be divided between union and the states in a certain proportion in order to effect on equitable division of the financial resources. Nowadays, this proportion has been increased in favor of the states to a 42%. But this category includes all taxes referred in union list except the duties and taxes referred to in Article 268, 268A and 269. Then there are surcharge on certain duties and taxes for purpose of the union. Parliament may at any time increase any of the duties or taxes referred in those articles by surcharge for purposes of the union, and the whole proceeds of any surcharge shall form part of the consolidated fund of India. Then there are grants in aid. Besides sharing the taxes between the center and states, the Constitution provides for grants in aid to the states from the central resources. There are two types of grants in aid. Number one, statutory grants. These grants are given by the Parliament out of the Consolidated Fund of India to such states which are in need of assistance. Different states may be granted different sums. Specific grants are also given to promote the welfare of scheduled tribes in a state or to raise the level of administration of the scheduled areas therein, as mentioned in Article 275. Then there is discretionary grants. Center provides certain grants to the states on the recommendations of the Planning Commission, which are at the discretion of the Union government. These are given to help the state financially fulfill plan targets. Then there is a finance commission. Although the constitution has made an effort to allocate every possible source of revenue either to the union government or the state governments, but this allocation is quite broad based. For this purpose of allocation of certain sources of revenue between the union and the state governments, the constitution provides for the establishment of a finance commission under article 280. According to the constitution, the president of India is authorized to set up a finance commission every 5 years to make recommendation regarding distribution of financial resources between the states. The Finance Commission recommends to the President as to the distribution between the Union and the states of the net proceeds of taxes, the principles which should govern the grants in aid of the revenue of the states out of the consolidated fund of India, the measures needed to augment the consolidated fund of a state to supplement the resources of the panchayats, and any other matter referred to the commission by the president in the interest of the sound finance. Then there is a Niti Aayog, which is one of the latest inclusion in the Constitution of India as per the financial relations between the Union and the state. It is basically it was formerly known as the Planning Commission, and it has started and around the work of the Planning Commission as it used to do. Then there are effects of emergency on center-state financial relations. That is, during national emergency, the president by order can direct that all provisions during division of taxes between union and states and grants in aid remain suspended. During financial emergency, union can give directions to the state to observe various canons of financial property, to reduce the salaries as I mentioned earlier, to reserve for the consideration of the president all money and financial bills. Thus, to conclude, we can say that in India, the center-state relations constitutes the core elements of the federalism. The union government and the state government cooperate for the well-being and safety of the citizens of India. They work together in the field of environmental protection, terror control, family control, and socio-planning. The Indian Constitution aimed at reconciling the national unity while giving the power to maintain state to the state governments. It is true that the Union has been assigned larger powers than the state government, but this is a question of degree and not quality, since all the essential features of a federation are present in the Indian Constitution. It is often defined to be quasi-federal in nature. Thus, it can be safely said that the Indian Constitution is primarily federal in nature, even though it has unique features that enable it to assume unitary features upon the time of need. Thus, it is federal, but its spirit is unitary.